On the set tonight is Honorable Paul Mwiru from Ginger East. Thanks for joining us on the show.
Thank you. Good evening,
my left
viewers.
Is Honorable Asumani Basalirwa. Welcome to the show, Honorable.
Thank you very much. I'm glad to be here for the first time.
Not the first time. You'll always be here.
Yes.
All right. Well, Honorable members, something strange has been going on in Parliament since for the last 2 days. It has been a controversial debate to do with women who have added names of their spouses, risk losing their political bids in the run to 2021. What does this mean to women and as Parliament? What are you doing about it? Let me start with you, Honorable Paul Mwiru.
Well, thank you. I think what we are grappling with is the transition to the new law, because with the amendment of the Personal Jurisdictions Act 2015, where the old voter register was retired, though we had issues with the mode in which it was retired. The Section 36 requires that actually change of name would require one to go through the process where you'd have a deed poll, you'd have to gazette, you'd even have to go to NIRA, and they change the particulars which you have registered. But now, what is an issue is as to whether when a spouse adopts the name of the spouse, like for instance, if someone's called Mrs. Mwiru, whether that amounts to change of name, and therefore should go through the process of complete change of name. But the paradox has also been that when with the enactment of the Personal Jurisdictions Act, we created a national register for all Ugandans where you would have particulars names, and under the same act, the Personal Jurisdictions Act, the Electoral Commission, which has the mandate of compiling, updating and maintaining a register, can pick data from any government department or agency for this matter, now NIRA. So they have been picking data from NIRA, which helps them in the compiling of the National Voter Register. So as a result, you realize that they pick names as registered by the spouses in that respective on the register. And when now it comes to presenting of academic documents, courts have interpreted the situations to mean that, like I'll give a live example, where the candidate last time in Palisa, who was supposed to become the woman member of parliament for Palisa, she was called Catherine Achola. And she had even contested before. She was on the old register as Catherine Achola. So the passing on of the dad, she adopted the name. When they went to register now in 2015, then the new register, she adopted the name of the father and she registered as Catherine Achola Osperem. Now, when it came now to nomination, but her academic documents, which even she used before to get nominated with the Electoral Commission, were Catherine Achola. And she had never been a candidate with the same academic documents. So the NRM was a political party, petitioned the Electoral Commission saying that Catherine Achola Osperem, who was the registered voter on the register, had no academic documents, as the documents she presented were for Catherine Achola Osperem. We went before the Electoral Commission. We made out our case and said, look, this is one and the same person. First, to us there is constructive knowledge on the part of the Electoral Commission that if you have ever nominated someone as Catherine Achola and submitted the academic document, you will deduce from the record you have, from your own record, that this is the same person.
Honorable Paul Mwiru, at that point, let me first also chip in Honorable Asumani. the interpretation to many of the legislators whom I think are paralegal, they were claiming that the law as it is, when it came into force, I think in 2016, is supposed to affect those, it's not supposed to affect those who had got married and adopted names of their husband before the enactment of the law. So those who are supposed to be affected are those who got married after 2016. What do you make of that?
Yeah, but you cut Honorable Paul Mwiru's argument, and I think he was driving towards that. But let's first understand two things. One, it is true there is a new legislation. That legislation is called the Registration of Persons Act. And that new legislation repealed what used to be known as the Births and Deaths Registration Act. I think it was CAP 309, if I recall well. Now, when you look at the old law and the new law, the provision on change of names is the same. It was not changed. The only thing what was changed in the law, in the new law, has to do with the age. Because the old law was saying that any person, whether a widow, widower, married, an adult, who is above 21 years and who wishes to change their names, they must have them gazetted. The new law has that same provision, only that instead of 21 years, it says 18. So in terms of similarity, there is no fundamental difference between the old law and the new law. That's one thing. Number two, what is the change of name? Now, the Supreme Court, in the case of Lulema Wia versus Muchibi Serunjoji, has said that change of name involves three things. One, either you are adding a name, maybe you are Basalirwa Asumani Mwiru, or you are Basalirwa Asumani and you are removing Asumani to adopt some other name, or you are completely changing from Basalirwa Asumani to somebody else completely. That even if you have initials, Basalirwa Asumani SAM, something like that, onto your names, that in itself constitutes a change of name. That's what the Supreme Court has said. But you recall at that time, election petitions would go up to Supreme Court level. Now, election petitions can only go up to Court of Appeal. Now, the Court of Appeal has given different interpretations, and that's where the problem is. The Court of Appeal is saying that if there are differences in names, you must, and you are saying these names or these academic papers don't belong to person X, then you should bring that person who is the owner of those documents. If that person is not brought, then the person claiming that he or she owns these documents is the owner of them. So with or without a change of name, if you are not bringing a person who says, these are my documents, somebody used some other person's documents, and that some other person is nowhere to be seen, then you cannot claim that those documents don't belong to that person. So I think that's where we really need to understand it. Now, there are different interpretations at the Court of Appeal level, unfortunately. In one instance, the courts are saying something different. In another instance, they are saying something different. So, when you are talking about married people, I think we are just narrowing it, but it's broader than that. It affects those who have new names or added names on their original ones, or removed some of their names. So it has nothing to do with the only married people.
But why are people fearing? Why are those to be affected fearing to swear an affidavit?
No, they are not fearing, but I think you should also understand, when do you swear an affidavit? Because there are two things. If you want to make a clarification on the names, then you are going to swear what we call a statutory declaration. if you are changing names, then you swear what we call a deed poll and have it gazetted. Now, the mistake most people do, and I think where the problem is, so if a lady adds a name of the husband, does that constitute change of name? And if it constitutes change of name, do I have to swear, do I have to have a deed poll? Or I can have a statutory declaration to say, I added this name when I got married. So I think nobody is fearing. What should happen is just to clarify. And I think that's what Parliament is trying to do. The engagement which we had with the Electoral Commission this morning was to the effect that that matter should be clarified. Those who are married, what should they present for purposes of them getting nominated?
At that point, let me cross over to Honorable Paul Mwiru. Now, we have seen people having marriage certificates. Now, in the context of the legal interpretation that's now playing out, do you want to tell the public that marriage certificates are not recognized in this context? They're just mere useless documents?
Well, as Honorable Basalirwa, you seem to be narrowing it to married people. But you see, as I said before, I say it is broad. But for purposes of, actually, for me, I don't construe adopting of a husband's or spouse's name to be a change of name, because it can be deduced from evidence. I think what the Electoral Commission would do in this regard, or what we would need to advise, is to say that if someone adopted the name of Basalirwa, and you are called you are called, let's say, Ratio Basalirwa, I would expect you to adduce a marriage certificate for that matter. To me, that would be a question of common sense. But the challenge, you see, now to me, that's the simplest you are talking about. But the complications one are where Asumani first Basalirwa, he was called the Asumani, well, Basalirwa Abudu on O level. When he went to A level, he had to call himself Asumani Basalirwa. He had abandoned the name of Abudu. You understand? Now, when it came to registration as on the voter register, it registered as Asumani Abudu Basalirwa. You understand? Now, even at this point, I am of the considered view that since the process of registering voters actually ended, you understand? If someone came today and said that now I'm going through the process of change of name, then you change the national register. Now, that will be valid, but it will not go to change the voter register. Because there were timelines of cutting off on the voter register. You understand? That's my point of contention. And in my view, I think what Parliament needs to do to avoid this halbalo, because I see very many people in Parliament, if we are to go by the strict interpretation of what the Electoral Commission is, because I don't even agree with that interpretation of the Attorney General, that this law does not apply to people who had sworn statutory declarations before it's coming into force. Because remember, even because those people registered under the new law as voters, therefore the same law under which they were registered should apply to them. But now that would mean that very many people would be cut off now at that point. And even if they, to me, in my opinion, even if they went ahead and they did change of name, they even went to NIRA and changed it, that would be for purposes of changing on the national register. But already remember, their names are already on the national voter register.
Now people need
and there will be a discrepancy between what they have changed and the academic
with
documents.
all the legal gymnastics that are playing out on the legal interpretation. This afternoon, in the morning, the legal committee of Parliament interfaced with the Electoral Commission and the principal legal advisor to government, the Attorney General. Honorable Basalirwa, you attended that committee. What are you settling in? What's the position of Parliament? What's going to be the way forward?
No, the way forward is that anybody, first of all, for those who adopted names of spouses, what they only need to do is to have statutory declarations confirming that fact and attach marriage certificates. It's really as simple as that. And there shouldn't be any contention on that aspect. Now, those who change the names, the example the Honorable Paul Mwiru gives, if you are Basalirwa Abudu in O level, and in A level you are Basalirwa Asumani, then on the national register you are Basalirwa Asumani Abudu. Those are different names. And those can be considered to be different people. Now, if you are saying you changed the name to Basalirwa Asumani Abudu, then that means you must have a deed poll, and that deed poll must be gazetted. And that is now, that's the only way out. So for those who have inconsistencies in names beyond marriage, they must have deed polls, because those inconsistencies are construed as change of name. But for people who are married, they adopted names of their spouses, the women, the ladies who adopt names of their spouses, they only have to have statutory declarations with marriage certificates attached. And the Electoral Commission should be able to understand that. You know, he talks about common sense, but it's also judicially noticed that in the world, especially not only in the Commonwealth, but it's a notorious fact that when women get married, they adopt names of their husbands. It is not mandatory, but it's a conventional practice that when you are called the name of your husband, it is not strange. So why would anybody be punished for that? So that's what we settled. I mean, you are saying what was agreed, that for the case of the married people, marriage certificates, statutory declarations explaining how the names came about, and these are really very simple things. And somebody and
those who are not married,
yes,
but they either adopted names of their parents.
Yes.
What's going to happen?
No, then you have to have a deed poll, because by adopting a name, you are changing a name. Okay, so you are changing a name, and therefore you must do what the law tells you to do. Have it gazetted, and you are good to go.
But why now? Why is the Electoral Commission bringing it now?
No,
what is the
because it has become a legal, it has become a subject of litigation. If you look at election petitions previously, the issue of names was not a very serious issue. Now, along the way, people discovered that there were a lot of, forgeries, misrepresentation, and borrowing of academic documents of some other people. So, and by the way, even the Electoral Commission has been nominating people in error. But now, because of the successive cases that have been brought to court, the Electoral Commission is just waking up to follow what exactly the law says. There has been a lot of laxity. So the issue you ask why now is because there is now a discovery that people are using papers that don't belong to them.
Now, point well understood. Now, we do understand that the legislative arm of government and the executive, they are locking horns now.
Over what?
Over to do with the issue of the local council 3 elections.
Yes.
Whereby you have people who are not yet 30 years old.
Yes.
Not being allowed to contest for either councillors, municipality councillors, sub-county councillors. Yet the law says that somebody who's 18 years and above should be in position to contest. Now, we do understand that government says, the Electoral Commission did say that Parliament is going to blame for that.
Well,
you concentrated on Article 102B that was to do with putting off the president's age and the LOC5 chairman, and you forgot the lower LOCs. So, do you admit that you erred as Parliament, and who's to blame? Well,
I think to put it in context, when there were amendments, I hadn't joined Parliament. The Honorable Mwiru was there, I think, at that time of Tojukwatako.
No, I wasn't.
You hadn't come. Yes, me and him came through by election. By the time these things happened, we were not there. But obviously, we were following whatever was happening. There was a constitutional amendment bill. That constitutional amendment bill was to do with the removal of age limit. And it was very specific. Remove age limit of 75 for the president. Remove age limit of, I think, 35 for the LC5 chairpersons. So, and then reduce the age to contest to 18. Okay? Now, remember that the Local Government Act had also provided that anybody who wants to...
Honorable Basalirwa, at that point, let us first go in for a short commercial break.
Okay.
When we return back, we shall start from there.
Thank you.
You're watching STV. Select for fun.
Abalamuzi babagamba nti if the incumbent president frustrates all democratic means to leave power, temusibayo muntu n'omu ku twizo. This is why Besigye is released. Museveni ekibi kyalina talina mawulire. Nawandika n'ekitabo kyange the role of which could have been a malicious society sapule njijjamu
noyingire sabo
katonda wa bujja nze katonda w'obujja bw'oba olaga eri sapule twekitwala omusajja omubbi bamujja ewuwe ewaka kabanga lyezi ne bamujja ewuwe ewaka yabadde mu ttooyi naye tebamukkiriza na tusanitize bamutadde butese mu piikaavu ba mu state house naye omukyayina bwe yawulidde nti ono bamukutte yeesize kiwi yayitiddeko yadduse ng'omuddugavu.
Hey guys, you're watching STV. Select for fun.
What's up, my people? So welcome. It's a beautiful, beautiful day. My name is Kai Imran and this is the Select Fix Up music.
Hey guys, you're watching STV. Select for fun.
We are back from that short commercial break. Well, Honorable Basalirwa, starting from where you stopped from, where is the contradiction?
So the argument I was developing is that there was, it is true, as you mentioned, there was concentration the amendment was on age limit for the president and LC5. Now, when it came to amending the enabling laws, the Presidential Elections Act was amended, the Parliamentary Elections Act was also, the Local Government Act was amended in as far as LC5 chairpersons are concerned. Now, the chairpersons of sub-counties, town councils and municipalities, that there was no amendment on that aspect. So it so happens that the Electoral Commission now calls for nominations. And people of 19, 18, 29 show up. So when they show up, they are reminded that the law says you must be 30 years and above. And these people are saying, but we understand the issue of age limit was resolved by Parliament. So it is true. There was a mistake on the side of government, on the side of they didn't address that issue when the matter came up. Apparently, the concentration was on the two aspects. That's why today they did inform Parliament that they are bringing an amendment to the Local Governments Act, okay? The age limit. And in the committee, obviously it has so many challenges. One, political parties have already conducted internal processes with that in mind. But also, two, the nomination process is going on. But the chairperson of the Electoral Commission did say that a nomination is for those lower councils will take place up to the, I think, 1st of October. So he said if Parliament can conduct that process before the 1st, then they can be able to fit into that arrangement. But it's still problematic.
But yesterday, the Attorney General was quoted having said that the amendment that Parliament did was unconstitutional. But the amendment that you had done for the local councils was unconstitutional.
It was in respect of women representation.
Not age of the councillors. Because what we are talking about is that the Constitution says that a third of local councils, a third of the seats of the local councils must be reserved for women.
But before we get into that, now, what is the way forward?
Yeah, but before the way forward,
on the issue of age,
you had skewed the facts to look like Parliament initiates the process of amendment. That's not correct. I want to say that the executive slept on job. Parliament deals with bills and they deal with what is contained therein. The way I don't want maybe even to waste a lot of time, but you see the way amendments are brought, they are brought by a cabinet memorandum, which is brought and sent to cabinet by the line minister. They have a whole technical department which would scrutinize and point out some of these issues. But so that was a lapse on the part of the executive, and we dealt with what they brought. We did not go, Parliament had no duty to go outside what they had brought unless it had been brought to our attention, which was not. So it's not true that Parliament didn't do its job the way it is being portrayed. Because as a member of the Legal and Parliamentary Affairs Committee, we dealt with the bills in the form that had brought, and we dealt with memorandum was presented by the stakeholders.
But the Attorney General did say that for them, as government, their interest was on Article 1.
Yes, now I'm coming to that.
The local
yes,
amendment that's causing controversy
was not in their interest.
Was not in their interest.
Fine.
It seems to have been an initiation of Parliament.
Which one? No. What, no, I don't. That's not correct. You see, the law as is as the one Basalirwa has stated it, that it requires must be 30 years for sub-county, town council, and the municipalities for you to go and nominate. Under the law, every law is valid for all purpose and intent until it has been declared challenged and declared null and void. So as we stand, the law is 30 years for those respective positions. So the way forward is for government, because they don't require a certificate of, maybe they can issue to themselves a certificate of financial implication than a private member's bill. So to me, the way forward on both the issue of the names and this question, it is a question of government introducing an amendment to section 36 of the Passages Act to stay its applicability to presidential, parliamentary, and local government elections. Then, in respect of this one also, an amendment also to bring it in conformity with the requirement for the president, parliamentary, and LOC 5. So there is uniformity. That is, in my view, that's what must be done.
But now, Honorable Basalirwa, even to get back to you, the deadline for these local council nominations they are closing on 1st of October, which is around next week. And Parliament is going to handle the matter after the collapse of the deadline. So what's the way forward?
Now, first of all, even before the collapse, Parliament is supposed to be going on recess on the 2nd of October. According to the communication, I think, which the Speaker gave. But this issue of deadlines, they are set by the Electoral Commission. And they are not cast in stone, they are not anchored in the law. It is not the law that says the deadline must be this, so that it cannot be changed. These deadlines can always be changed by the Electoral Commission through a notice in the Gazette. It's the Electoral Commission that sets dates. So there is absolutely nothing wrong for the Electoral Commission to take cognizance of the current crisis and perhaps extend the deadline. So that's one aspect. But as I said, there are now practical difficulties. What is going to happen to internal party processes? Are we going to invite fresh nominations at the level of the political parties? Number two, there are instances where in some places people have been nominated and they are unopposed and have been declared unopposed for those positions. So now these people, if the thing is extended, you are now going to invite competition. What is going to happen? But there is also a bigger problem. A bigger crisis will actually be the implication on the general electoral calendar. The difficulty that is likely to come out of any extension of a deadline. And I think that's where the Electoral Commission and government must harmonize. Otherwise, it's going to be a very big problem. I agree, the deadline is fast approaching, but we also have a crisis. Because you see, it does not make sense to have all other positions, to remove the age limit on all other positions, and then you are putting it on lower local councils. Because our democracy begins from there. It just doesn't make sense. So it's only logical that we try as much as possible to create harmony for the various elective positions. And I think that was the purpose. The purpose was not only to remove age limit for the president, but the purpose was to remove age limit across board.
Okay. Actually, it was a decoy.
Yeah, exactly.
The president just brought in others. So as is amending, it looks like even others are benefiting.
Yes.
But because they were acting in the bad faith, all this was bound to happen.
They forgot. So I think we, as Honorable Paul says, somebody slept on the job, but now that the anomaly has been realized, it should be corrected as quickly as possible, and it should be corrected in the right way. Because if we don't also...
Are we seeing... now, what you mean is that as Parliament, you are pushing the law to be bent?
No.
To allow...
No. It's not pushing the law to be bent. Actually, what Parliament has advised is to amend the law to cater for the present situation. The Honorable Paul has told you we could amend even the Registration of Persons Act to suspend the operation of Section 36, amend the Local Government Act to remove the age limit. So there is no bending the law. It's about using the correct processes to address the situation. And the correct process is amending the laws we are talking about.
Let us rush into the issue of to do with women demanding for more representation on a sub-county level and municipality level. We would like to know. The old law was talking about 3. The old law was talking about having each sub-county being represented. Is it the position?
That's not the old law. As a matter of fact, that's the new position. The one you are citing is the new position. The amendment seeks to ensure that every sub-county is represented by a woman.
And a man and a woman. Yeah.
By a man and a woman. Because you see, there has been a challenge where in some sub-counties, you would find a woman representing 2 sub-counties. And a man represents only 1 sub-county. So there has been that unfairness. That's why there was an amendment to the effect that every sub-county should at least be represented by one woman. Sub-county, as opposed to the situation that has been obtaining where you find 1 woman representing 2 sub-counties. Now, there is the constitutional requirement of the 1/3. That constitutional requirement simply means that in local councils, 1/3 of the positions, the elective positions, 1/3 of the representation on councils is reserved for women. That's the minimum. So we should be working towards addressing that minimum. Now, already in the present situation, if you look at how these councils are composed or constituted, that minimum is met. The issue is to implement the provision of ensuring that at least every sub-county is represented by 1 woman. That's where the discussion is now. That's where the debate is now.
Now, to what I understand that the Electoral Commission was moving with the old position of having 1 for the 3 sub-counties. Parliament, you are pushing for 3. Each sub-county to be represented. Now, world over, the world is struggling to cut costs. Now, here in Uganda, you are working around increasing the numbers, and at the end of the day, we are going to face what we call the public cost, the cost of public administration. So, is Parliament addressing itself to that challenge? That, again, by having 3 people, each person representing a sub-county in the context of women, it's a matter that, again, is likely to raise the cost of public administration. How do you want to step into?
First, thank you. Well, I think the amendment in the Local Government Act, which we dealt with, still the executive slept on job. They ought to have started with a constitutional amendment, then came with an amendment, the Local Government Act. Whereas we amended the Local Government Act, the Constitution was not amended. So that's why the Electoral Commission was saying that we cannot implement the Act, the Local Government Act, because Article 2, Sub-Article 2 says that any other law or custom which is inconsistent with the Constitution is null and void to the extent of the inconsistency, meaning that they will not implement. Of course, on our part as Parliament, once we receive the bill, we have to deal with the bill the way it had been brought. Of course, under an assumption that the Cabinet would bring a constitutional amendment bill to address the issue, which they did not do. So at that point, still it is I say it is the executive which left on you. But on the question of increase of public expenditure, I think the biggest problem we have in the country is over-representation. If you are gerrymandering, creating costs even which are unnecessary purpose of people just coming to Parliament, then why shouldn't we do it for the councillors also? Because it seems politics is the fastest growing industry now. that to the extent that even when you, because I see it when you go to the constituency, that even some of us who are ideological, who are looking at politics for the good of society, some people look at it as if they have given you a job, you have got something, you know, it's a deal. She will have got to that level. You understand? So if you find the leaders in form of executive who think that this is like a reward system, because I've been watching the local government council election, the NRM primaries. In my area, the youth were buying a vote at 500, 300,000 shillings because they wanted to win. Then that kept me wondering.
But Honorable Mwiru, two wrongs do not make a right. If the executive is making mistakes with involving itself in political gerrymandering and so on, it shouldn't mean that also the legislative arm of government should do the same mistake. Should do a mistake because the executive has done it.
No, we are very clear. We know we are, as opposition, we presented the Constitutional Amendment Bill, which is being debated, moved by Honorable Winfred Niwagaba on behalf of the opposition. Actually, we are even proposing that each district should be represented by one woman and one man. Try to reduce even the size of parliament. That's what we are suggesting. So, in as far as we are concerned as the opposition, every much they will go do the gerrymandering. First, we have been saying we must cut the cost of public administration. That's why in the Nwagama bill, we are scrapping RDCs, we are reducing, we are saying every district must be presented one man, one woman. So that we reduce the cost, the size of parliament, even the cost of public administration.
Should this be a do or die thing? Increasing the number of women representing each sub-county? Should this be a do or die?
No, it's really about...
Because you see, the way I saw the debate, the House is being driven by voices of women.
No, it's really about equity. It's really about equity. Because, you know, and you have only to look at what our Constitution says and also look at our history. History has disadvantaged women for a very long time. And the disadvantages are numerous. Either it is the cultures, disadvantaging them, or various forms of, various practices disadvantaging them. So that's part of the affirmative action that the Constitution talks about. And for us in the opposition, as Mwiru is saying, we want to have that debate once and for all. Not only at the level of district, but we want at all these levels of representation. Let's talk about equality. If it is at sub-county level, let every sub-county have one man, one woman. If it is at a district level, representative, let it be that. So that that debate is completed once and for all. We don't want to engage in it anymore. Because we are likely to drive ourselves into that conversation for a very long time. It's really an issue of equity. It's an issue of realizing that history has in one way or the other disadvantaged women. It's a recognition of where you are coming from, the practices, the cultures, and the chauvinism or patriarchal society, as we want to call them, and the like. It's really a recognition of that. It has nothing to do with saying that is this a life and death issue. Because if before they were not being represented, what was the problem? If the time is now to call for their representation, is that bad? Is that what you want to call do or die? It's not really that, in my view.
All right. Okay, let us move away from that. Let's try to delve into